This trial almost moved forward without a live witness. The prosecution relied on a surveillance video and prior sworn testimony, but before jury selection, the judge stopped everything to review the law.
Witness testimony, the evidence, one video, because evidence one introduces surveillance video that was introduced during the murder trial, what we call the sound not guilty. And that eventually it shows what is the sponsored witness of that video out of the country will be out for a month. Under Rule 804 of the Constitution, evidence, I believe, can use the prior testimony of that sponsored witness that we would subject to determination by. We have secured transcript of the witness's testimony. We provide a copy of that to Mr. Wilkerson, and the court will allow us to use the transcript. There's no need for it. Your Honor, I didn't come prepared to argue that the first learning of unavailability unless Mr. Coleman proved something yesterday.
Not see anything. There was I guess, just recently filed a notice of intent to introduce transcribed testimony.
I did not. With regard to that, the counsel testimony as well, you fully advise you to stand.
Which, Robert Johnson, remind me what I'm...
Romeo Johnson, never tried with these were one of the twin brothers, the Barnes.
Yeah.
Yeah. You will call the brother was in a wheelchair.
Give me just a second.
Barnes,
Yeah, you're right.
Judge, I know you're reading for Judge Freeze. Help me to let you know we're in a day trial.
No, it took me just a second.
Yes, Your Honor.
I don't know that this would...
My interpretation.
I mean, under 5, so 804A5.
804. Yeah, thank you.
Well, first is A is the criteria for being unavailable. So a declarant's considered to be unavailable if. So you've got to get one of those 5 to be unavailable. Then you go to B. So it's not 1, 2, 3, or 4. So 5 would be the only one possibly. It states that is absent from the trial or hearing, and the statement's proponent has not been able by process or other reasonable means to procure the declarant's attendance or testimony.
That's what we're hanging our head on today. My initiative is case is here. Can't file the office.
Okay. And so, all right. So if we're going to get into that, we'll wait and do it at another time. I'll either lunch or like tomorrow morning or something.
Yes.
Because I need to set. This is probably. We're down to maybe 2 cases. So I will need to make that decision and number the cases. So let's do this. Because I would need to hear that information. I think I want to look up a little case law just to make sure. So you've got one witness?
No witness at all.
No, one witness that's unavailable.
Yes.
And that witness would be sponsor.
It shows
and then the. I just feel like without reading that, and I've never had this come up, where in his own trial, introducing testimony seems to violate Fifth Amendment. Well, I mean, it's almost like you're forcing him to testify by putting on prior. I don't know. Let me look into that.
Party part. I mean, you don't stand under the tip.
I just need to do some research that if it's I know if it's another party potentially talks about when it's a criminal case, what's given as a witness at a trial or hearing of the current or a different proceeding and is now offered against the party.
You very well could be speaking right in the you did it not.
Okay, let me look into that. You look into that as well. So 804, it looks like we've got two things. One is under A with regard to the unavailable
Yes, sir.
witness. The other is under B, which is the former testimony of your client. So let's, I'll give you an opportunity. About how long do you think you guys will be going?
We anticipate finishing this afternoon, Judge. Come back on the lunch break, or
No. You're in the middle of a trial. I don't want you to have to think about this and do that. I will number the cases tomorrow morning. So let's take care of this. Are you available to come? It won't take long. That gives me some time this afternoon to also do a little research.
I've got another case in the 317th, oddly enough, but I think I can kind of delay
If you can
that.
come here first.
Yes, sir.
It won't take us longer than, it'll take 15 minutes. I mean, there's really, I'm assuming you're investigator, it will be quick testimony as to the unavailability. Other is just legal issues that we all need to just look at.
Oh, that's for a trade out.
Perfect. All right. So head back down there. We'll get you back over here tomorrow morning, 9 o'clock.
All right. Thank
Okay.
you.
Sounds good. And if everybody gets here a little early, we can start early. I'll try to be here early as well. All right. Go back with the bailiff. We'll see you tomorrow. Yes, sir. You'll come back tomorrow, and that way we know what's going on for sure if you're going to trial or not. Yes, sir. Good morning. How are you?
Fine. Thank you.
Ma'am? All right, ma'am, you're Louisa Magruder. And Ms. Magruder is currently on probation for sexual assault of a child in cause number 1625158. Motion to revoke probation has been, or motion to revoke unadjudicated probation has been filed. And Mr. Bynum, give an announcement.
Yeah, we're ready. Yeah. Speaking with members,
Sure.
myself and wife, still not shotgun computers. She's actually one of the class plaintiff with still in the large civil rights case related to bail. So, you see the judge very bail. I know her because I was trying to do this. And, but I agree with becoming a lawyer, I don't have much of a conflict of practice. So, the lawyers in the case told me what I see. They say about being on MAJ is that I'm the last recording. Everyone in here. History. They yeah, right in there. She's fine.
Let me stop you. I guess just as far as kind of procedurally,
Yeah.
If there is the way I'll handle all of the motion to revoke. So if there's an agreement, y'all can get that taken care of, do paperwork for whatever's going to happen. If there's not an agreement and you want to argue for me to do certain things,
Right.
then what I'd rather do is go through the motion, get pleas of true or not true, and then what I do is reset the case for sentencing hearing. So everybody has time to provide whatever information they want, bring in witnesses they want. Probation will do an updated pre-sentence report that'll give me more information, and then I'll listen to all of that on that day. Okay?
I just where I was going with what I'm sorry. I was wondering if the court should TRAD
So it would all, what would happen is I would still get an updated report because I need to see what all I mean, if they agree to that, then yes, I will consider it. So if y'all have an agreed recommendation, yeah, she cannot go because of I didn't think her underlying offense. She's not eligible. No, please. Yeah. Okay. We've been here before. I feel it's unfortunate that I recognized Miss Magruder over the last few years, and so apparently I have. So okay, so all right. So here's what we need to do then, based on that, just so that we can all get caught up, is get the pleas of true or not true to the allegations, and then reset it for a hearing. You can provide whatever you need, argue whatever you want, bring whatever witnesses. State can do the same. We'll get that updated report, and then I'll make a decision. Okay? So let's do this then. Ms. Magruder, please raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, thank you. You can put your hand down. And will your client waive the formal reading of the motion? So, Ms. Magruder, in cause number 16-25158, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation January 29th of 2018 for sexual assault of a child, second-degree felony, and that was a 10-year deferred probation. Is that correct? And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department on May 23rd of 2025 and to the administrative hearing on June 2nd of 2025. And is that true or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true? Count 3 alleges that you failed to submit to alcohol and or drug screening on June 2nd, May 28th, and May 19th of 2025. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of June 2nd, 2025, in the amount of $8,645. Is that true or not true? And then count 5 alleges that you failed to enter and successfully complete the Jefferson County Drug Intervention Program, JCDI, and that's from the order from September 24th of 2024. Is that true or not true? All right, so I will have pleas of not true entered for all 5 counts. Again, we'll reset the case for sentencing, and I will ask for an updated pre-sentence report. Obviously, anything that you think is important for me to know, get that information to Mr. Bynum. He'll present it to me on your behalf on that date. All right, we'll see you back on that day. Thank you. Good morning. Are you Derek Green? And will your client waive the formal reading of the indictment?
Sure.
Let's see if we're going on less. Correct.
Yes, Your Honor.
I'm getting there, sorry. All right, Mr. Green, in cause number 25 DCCR 1119, the state has elected to proceed on count 1 only, and in that count, to the lesser included offense of a Class B misdemeanor terroristic threat from June 19th of 2025. And how do you plead to that charge? And are you pleading?
At the center of the dispute was Rule 804 of the Texas Rules of Evidence. The court examined whether a witness was truly unavailable and whether former testimony could be used. Even routine trials pause when constitutional rights are at stake.
To appeal. And are you a U.S. State Tenders number 1? It's admitted. Is there any evidence that Mr. Green is not?
Oh, yeah.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of a Class B misdemeanor terrorist threat. Sentence you in accordance with your agreement to a term of 150 days in the Jefferson County Jail. You will receive credit on that sentence any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you.
Thank you.
Good morning. No. Oh, yeah. At some point, we got to go forward. All right, you're Andre Williams. And so Mr. Williams' case is set for trial to be a jury selection Monday. Announcement.
Judge, I've talked to Mr. Nick. I'm asking for 30 days. I finally got some clarification on the Social Security records that I'm trying to obtain. They told me how to do it. They'll either let me know they're ready, I send them an invoice, they'll give them to me. They'll certify them, they'll make them court admissible. The court doesn't have to, nothing about an order from the court or a writ or anything like that. They told me it may take up to 90 days, and that was 60 days ago when I think I finally got on the right track. So I'll do something, if I don't have them then
Meaning you believe that they're necessary for the trial?
I think, like the court pointed out, that they may be necessary in mitigating.
Mr. Nichols?
Mr. Gatkins got me up to date on this. So, Judge, we discussed trying to resolve the case.
And I guess, would the state trial be going on the murder?
Yes, sir.
I don't want to wait for all of this
No, Judge.
for mitigation on a murder if you elect to go on.
No, we're going forward.
Okay. All right, so I will reset. It will be on the next trial docket, which should be more than enough time. That's about 75 to 90 days-ish for our trial docket. And then at that point, it'll be time.
Thank you.
It's getting old, and it'll be time to get the case. Okay? All right. And as always, I've said, if you need any help, let me know.
Thank you, Judge.
All right. Thank you.
Thank
You can go back with the bailiff. Good morning. Are you Dominique Lee? And this is 25 DCCR 1784. Mr. Lee is charged with criminal mischief from October 14th of 2025. What is the announcement?
Good. I talked to Mr. Lee about the situation right now. So they give the information I do need to take out in regards to probation. He had been received his own looking for his schedule that probation. I think they may give us an option to try to
Probation here or somewhere else?
Yes, sir. Yes, sir. Oh, here. Yeah, I we spoke about this, we got like what is
Bumps it up to a second. But if there's do you show it active? So there would be an MTRP if there was. All right, I'll reset it so you can figure that out. Because if there is a motion, I would assume that there would be a motion. I mean, if there is a probation, I would assume there would be a motion to revoke. So I'll just do a normal reset to give you some time to get all that worked out. If you'll check into it too and see.
I did the prior to killing. I don't have to run it off.
Okay.
Sure.
Talk to probation, talk to him more, see if you can figure it out. Otherwise, we'll go forward with what we got when we come back.
Okay, that my understanding is that kind of what led him. He was in custody at the time and then was released when he received probation. His allegation occurred inside the jail.
Criminal mischief?
Yes.
Okay. Oh. Okay. I'll let you guys check on it and see what it was and if he got the probation after the incident. It's okay. All right, we'll figure it out. Y'all figure it out. Okay, go back to bailiff. Thank you. And then Maribel, is it Reichel? Good morning. Are you Maribel Reichel? And Ms. Reichel, in cause number 25, DCCR 0664, you're charged with a state jail felony offense of unauthorized use of a vehicle from April 2nd of 2025. What that means is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
On the rejection case, there was one. She only got one. Yeah, well,
There's so is there some criminal history? There is. It's just not in the indictment. And so what would the criminal history, would it enhance? Okay, but there's enough, but this, it would not enhance. So the state has made an offer. I have a plea bargain rejection that you've signed here with Mr. Lewis. It shows that the state's offered 1 year in the state jail if you wanted to enter a plea of guilty. You have every right to reject that and have a jury come in and determine if you're guilty or not. And if they find you guilty, you can leave your punishment up to them. I just want to make sure today that you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Ms. Reichel, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him. We can appoint another attorney today who can begin preparation for trial or quick. Is that okay with you? Okay. And he can. It's totally up to you. You would. Okay. So Mr. Lewis will remain as your attorney and begin preparation for trial. All right. You can go back with the bailiff. Thank you. See, Ms. Perazzo, you have Thaddeus McCrae. Maybe that's why the closure and holidays. Okay. Am I thinking of a different one? Is this the one where the victim and the aggravated?
Started.
This is a different one. As far as I was thinking of another. Okay. Yeah. Okay. Got it. All right. So you're Thaddeus McCrae. And Mr. McCrae is currently on probation for aggravated assault causing serious bodily injury. A motion to revoke has been filed. Obviously, the main allegation is the new offense of the alleged murder. And it's my understanding that it has not been indicted yet. What I'm going to do is one more reset on this motion. Mr. Smith, I know it's only been less than a month, I guess. Well, a little over a month. If you'll please get with intake and
We'll try to find
figure out when, and if you'll let us know that, but I'll do one more reset. But if for some reason there's some issues, I can't just keep holding this for that. So this will be
The judge declined to rush a decision. Instead, the court delayed proceedings to ensure the law was applied correctly. In criminal court, preparation matters, but legal accuracy matters more.